I'm Sean Ormonde. I'm the solicitor or a solicitor and the principal here in Employment Matters. I want to talk to you today about pregnancy discrimination in particular, really a whistle-stop tour, I suppose. We're going to give you just a quick taste for what discrimination means, in particular how it relates to pregnancy, and I want to give you some advice as to what you should do if it happens to you, what your options are and what's involved in those options, and I suppose what you can expect as an outcome. Before I start, I suppose I just wanted to apologize first of all to all of those who were booked to attend our last seminar in March. Unfortunately, that seminar had to be postponed. My colleague Jade Wright, who was due to host that, went into labour on the morning of the seminar, so unfortunately she was unavailable, so we had to cancel at short notice. So like I said, apologies to any of you who were scheduled to attend that. So I suppose I really just wanted to start maybe by telling you a story about one of our clients, Christine, who was one of our first clients in a pregnancy discrimination claim. And Christine came to us probably, I'd say 12 years ago now at this stage. She was working for a well-known national agency in Waterford as a healthcare assistant. And so she was working there for, I think, maybe 12 or 18 months. One of their most trusted staff. She always had excellent feedback from the company and from the service users, and really loved her job and did a good job. So much so, in fact, that she at that stage was training some of the other staff. There's a lot of churn in that industry, as you can imagine. In any case, like I said, she loved her job, and she learned the happy news that she was pregnant and was overjoyed and obviously felt that she must tell her employer. And lo and behold, having told the employer about her pregnancy, her hours began to dry up, and she couldn't figure it out. And then she was being told that that there weren't enough hours, that the service users, there had been cutbacks, etc. But she knew that a lot of her work colleagues were getting hours, and she couldn't figure it out. And then she found herself in a situation where she was being criticized unfairly, and effectively she felt that she was being pushed out. And ultimately, she resigned her position, and she was really upset. And I think probably her self-confidence, as much as anything, had been badly damaged and badly affected by everything. And she spoke to her dad, who contacted us, in fact, and we arranged to meet Christine, and we spoke to her about what her options were. And she decided that she was going to take a case to the WRC and asked us to help her with that. So we filed her complaint. We ran the complaint in the WRC, and they fought her tooth and nail every step of the way. But thankfully, Christine stood up to them and ultimately ended up having won her claim and being awarded a significant sum of money for her troubles. And to Christine, it wasn't about the money. And that's what I suppose we find most of all in this area, is that it's not about the money. It's about the principle of the matter. And in particular, for a woman who finds herself in that joyous time to be, I suppose, to be treated so unfairly. Certainly a lot of our clients really want to stand up to an employer for doing that, because we have to remember, this is your pregnancy. It should be a really stress-free and joyous time. And I suppose one of our mantras is that you shouldn't let anyone take this special time away from you. It's hard enough to do the job of growing another human being without having to put up with unfair treatment and harassment along the way. So that was Christine. Another one of our clients, Sinead Veriker, was a case more recently. It was, I think, a case that ultimately was dealt with by the Labour Court back in 2020, 2021. And Sinead had worked for her employer in Kilkenny for about 24 years. She started with them when she was 16. And she had made her way up the company, eventually gaining the position of general manager. And she was on her 4th maternity leave when she contacted us. And what had happened was she told her employer, who was actually a close friend of the family, interestingly, and she lived in a quite a small part of Kilkenny where it was a very close-knit community. So it was really difficult for her to decide to take the step that she was going to challenge her employer about how she was treated. But what she found was she was on her 4th maternity leave, or coming into her 4th maternity leave. And in her previous 3 maternity leaves, she had come back relatively quickly. And she decided that because this was her 4th and most likely last maternity leave, she wanted to take the full extent of her of the leave that she was entitled to. So she wouldn't be returning early on this occasion. And when she told her employer that, unfortunately, her boss, the main man in the company, took really grave issue with this, and got very affronted by it. And his attitude towards her changed dramatically. Having worked together for close to 25 years, he suddenly turned from being a person who was very supportive and friendly towards her to someone who was really quite mean and very antagonistic towards her. Ultimately, she decided, because she maybe felt guilty, I think, that she might be leaving her employer down. She did return from work, not quite as soon as return to work, not quite as soon as he would have liked, but really, I suppose, when she was ready, but sooner than she had hoped. And when she did return to work, in the first week of her return to work, she discovered that her boss's attitude had remained the way she had experienced it when she told him about her decision not to return earlier in the year. And he treated her really appallingly, based on the instructions that we received, and really made life miserable. Withdrew a lot of the jobs that she was doing. Gave her menial tasks. Like I said, she had been the general manager of the organization, and now she was being asked to do jobs that she had done 10, 15 years ago, and staff who were a lot more junior than her were now being given her jobs to do. So initially, when she contacted us, she was in a quandary because she just wanted to resolve this. She didn't contemplate that she might need to go and take a legal action against her employer. And so we began corresponding on her behalf with her employer, and ultimately we came to the realization that unfortunately she was going to have to commence a legal action against her employer in the Workplace Relations Commission, the WRC. The part of the reason for that, of course, is the practicality of actually taking a claim, that there is the statute of limitations that says that you must take a claim within 6 months. And so rather than let that statute of limitations expire, we lodged her claim. And unfortunately, again, the claim didn't resolve, or her and her employer weren't able to resolve her issues. And in fact, she ultimately resigned her position, and we pursued her case, like I said, through the WRC, where we were successful. And she received a substantial award. And unfortunately, the employer chose to appeal that case to the Labour Court. So all told, her case, of course, COVID intervened as well in the meantime. And I suppose all told, her case ultimately ended up in the Labour Court last year, possibly 2 years after she initially resigned her position. And again, in the Labour Court, following a hearing, the Labour Court upheld her complaint, and in fact increased the award in that circumstance. And ultimately, she achieved an award of I think it was in the region of 80 or 90,000 euro. But again, from her perspective, it wasn't about the money. It was about the principle that, you know, she had done 24, 25 years of loyal service, and that this was how she found herself treated. So I suppose what I want to maybe look at and maybe chat to you about briefly is just, what is discrimination and what does it mean? And so in terms of Christine and Sinead's perspectives or cases, what was the legal thing that we were trying to establish? Now, I'm not going to spend too much time on this because I'm sure everybody has better things to be doing than to be listening to legalese. But effectively, what discrimination means is it's less favorable treatment of one person in comparison to another. So that's at the top level. And so what you're doing is you're looking at two people in similar roles, and you're comparing, is one being treated less or more favorably than the other. To be discrimination in Irish law, or to constitute employment equality discrimination, you must fall under one of the 9 grounds of discrimination. So you must fall under at least one, and you can fall under maybe more than one. So it could, for example, be gender discrimination and disability discrimination, or it could be age discrimination and religious discrimination. It covers past, present, and future situations. And maybe by way of example, an employer who's always paid a female employee one rate in a certain position or role, but now currently pays a male employee more for the same role, that could constitute discrimination. So what are the 9 grounds? Now, I hope nobody would test me on this, and I've actually written them down just so we don't forget any. So what do they constitute, or what constitutes a ground of discrimination in Irish law? It's gender, marital status, family status, age, disability, sexual orientation, race, religion, and membership of the traveling community. So they're the 9. And I suppose the ones that we come across most frequently are gender and family status in relation to pregnancy, and age and disability are ones that we come across a lot as well. So what I know I touched on discrimination there, but what is it? How do you recognize it? And sometimes it is hard to know. I mean, a lot of the time we'll get inquiries from people who maybe feel that they're being unfairly treated, feel that they might be bullied or harassed or being subject to less favorable treatment. And so I suppose it is a tricky concept. And like I said, I suppose the main thing here is that we're looking at this comparison, or having a comparator, and trying to decide in relation to someone else, are you being less favorably treated, and is it under one of the 9 grounds? It doesn't have to be done directly either by the employer. It can be done by anybody in the workplace. And just to say as well, it's not necessarily what we're covering in detail today, but the Employment Equality Acts prohibit discrimination or less favorable treatment, but also harassment. And harassment is any sort of inappropriate treatment or conduct towards an employee. Again, though, that's linked to one of the 9 grounds. So maybe looking at pregnancy discrimination, and what does pregnancy discrimination, and actually as we saw there, pregnancy discrimination isn't actually one of the 9 grounds of discrimination. Pregnancy discrimination fits in under the gender ground. And obviously it's a uniquely female situation. So only a woman can be subjected to this form of gender discrimination. And really what it is less favorable treatment based on your pregnancy. And it can take many forms. It could be a refusal to hire you. So it can happen even before you're employed. It could be being fired or made redundant because of your pregnancy. And that's one that we see. It's surprisingly how common we see that. It could be a failure to promote, or failure to provide or to award a bonus because you've been on maternity leave, or a failure to provide opportunities like training. Or again, one of the more common ones that we see is somebody who's returning from their maternity leave, and they're returned to a different job or a lesser job in that they're demoted, for example. Or then it could be unfavorable comments or an unfavorable attitude, I suppose not dissimilar to what Sinead suffered when she returned to work, that she found that the attitude of the the employer had changed towards her, and now she was being treated in a very adversarial or aggressive way. So what should you do if you have been discriminated against, or if you think you've been discriminated against? So you have 6 months to take a claim in Irish law. And again, like we said, going back to one of those other cases I mentioned earlier on, that's why we had to act, because that 6 month period can be quite short, and particularly when you've been on maternity leave. The 6 month starts, or the tipping point that starts that 6 month period from running is the act of discrimination. So, for example, if you were discriminated against before you went on maternity leave, and then you went on maternity leave and returned and felt that you were going to take a case in relation to the discrimination that happened prior to your leave, you could find yourself statute barred. And so I suppose that's probably the most important thing to bear in mind, that time limit is tight, and it's very strict. It's really very difficult. There is a provision that allows you to extend the period of the statute of limitations from 6 to 12 months, but it's very, very difficult to do. And most people, and I suppose you couldn't be unduly criticized for thinking that, well, actually, I engaged in the internal procedure and I followed that, and that was the reason that I didn't take or lodge my claim in time. But unfortunately, in law, that doesn't suffice. So even if you are following an internal formal grievance process, you should lodge your claim in any case, just to keep your rights protected. And you can even, we've often seen it or done it on behalf of clients, informed the employer that, look, we're lodging this claim just so that we don't prejudice our clients, so that the clock is ticking in the background. And if the claim resolves, all well and good, the complaint to the WRC can be withdrawn and set aside. I think one of the most important things, or one of the most important pieces of advice I could give to someone who finds themselves in a position where they're being treated maybe less favorably than they might have been before, is to make really good notes of what's been happening to them. Because ultimately, if this did end up in an adversarial hearing, those notes could be crucial for I suppose corroborating the evidence that somebody might want to give to the Workplace Relations Commission. Because I suppose in this area, people rarely discriminate in the open. They do it kind of, I suppose, under the radar, as it were. And if you have a diary or some notes that are supportive of your position, it's very helpful in convincing an adjudicator that this has happened to you. So in terms of what happens then in the WRC, if you did choose to file a claim with the WRC, what does that look like? And I suppose, again, the one thing I would emphasize is, if somebody feels at all that they are being treated unfairly or less favorably, take legal advice. There are plenty of good solicitors out there who will hear you out at no, if any cost, or a small cost at the very worst, and they'll give you advice, and they'll maybe look at it from an independent perspective to tell you whether or not you do have a case. If you do have a case, like I said, and you're within that 6 month period, you can lodge a claim with the Workplace Relations Commission. So the Workplace Relations Commission was set up back in 2015 to take over from the old Employment Equality Tribunal and the Employment Appeals Tribunal, and it deals with all employment related claims. It's effectively like our employment courts, and there are about 55 adjudicating officers who've been appointed, and they're effectively our employment judges, and they hear all types of cases, and they would hear claims like this. So the start of that process is that a claim is filed with the WRC through their own online portal, and that stops the clock. And once that claim is lodged, the employer is notified that a claim has issued. And usually if we're acting in circumstances for a client like this, we would also write to the employer to inform them that a claim has been filed. And I think what's important to remember there as well, and what we would always do at that stage, is we would ask the employer to provide us with a copy of the not just the personnel file of the individual client, but all of the data that they hold about that client. So it's called a data access request, and it's a request under the Data Protection Act for the employer or the data controller, who the employer would be, to provide that information. And that's very helpful because particularly in circumstances, like we said, where a client might have been passed over for a promotion or may not have been paid a commission, there may be documentation there relating to that. Or there even might be emails between people within the company that discuss this situation. Or, for example, if somebody has been subjected to unfair disciplinary action, there may be something in there that would assist. So having been provided with that information, we would then go about drafting legal submissions. So the WRC, the adjudicating officer, requires legal submissions to understand what the case is about. So effectively, it's setting out in chronological order what's happened to you, what's happened to the claimant, and what breaches of the law apply. So those legal submissions are filed with the WRC and served usually on the other side, and that gives the other side, then the employer, the opportunity to put in replying submissions. So obviously an employer is likely to deny that anything inappropriate has happened, and as a result they'll file those replying submissions setting out what they say happened, the issues that they might take with the claimant submissions, and what they say the law is and how it applies. And so now the adjudicating officer should have a set of submissions from each side, and a hearing. The Workplace Relations Commission Secretariat of the WRC will schedule a hearing date where both parties can attend and give their side of the case. Now, in the WRC, under the Employment Equality Acts, and under the Employment Equality Acts, it's for the complainant to prove their case. So the complainant must prove certain facts that infer discrimination. And because of that, the onus of proof being on the complainant must go first in evidence to prove to the satisfaction of the adjudicating officer that something has happened here. And so, for example, if a pregnant lady is told while she's on maternity leave that her job is gone and she's being made redundant, on the face of it, or as we say, prima facie, that is an indication of discrimination, because a pregnant lady has been dismissed, and those two facts would combine to suggest discrimination. It's now then for the employer to come back and to disprove that, or to give an alternative version of events. So the adjudicating officer here's the case from both parties, and the adjudicating officer doesn't make a decision there and then. The adjudicating officer will reserve their decision, and they'll go off then and write up a decision, and that will issue usually, well, they say within about 8 weeks. It usually takes 3 or 4 months to get a decision. If that decision is positive in favor of the employee or the claimant, the employer can appeal that. Well, in fact, either party can appeal that decision to the Labour Court, and the Labour Court follows a similar process. It's very difficult to get a claim over the line in the WRC, particularly in the discrimination area, and particularly in pregnancy discrimination area. If you do get it over the line, though, it really is at the top of the tree in terms of how seriously the WRC takes complaints. And it usually does, if a successful complaint will usually elicit quite a significant award. We find, though, that a lot of cases don't ever make it to hearing. The WRC offers an excellent mediation service, and if the parties opt for mediation, a mediator, who is an adjudicating officer, will meet the parties and try and come up with a reasonable middle ground that both parties are satisfied with. The mediator acts as a go-between, and the mediator doesn't impose anything. He or she's not making any decision. They simply hear the sides and effectively just try and narrow the issues and come up with a resolution that works for everybody. Like I said, if mediation doesn't work, it can go to the adjudication process. But often, even if mediation is unsuccessful, and a hearing date issues for adjudication, one party or the other might contact or make contact, and that can lead to a resolution. So in our experience, probably 70% of these cases resolve with ever actually going to hearing. So what are the most common questions we get? And we get about 100, well, over 100 in March. We got about 130 inquiries from people who found themselves in a situation where they might be unfairly treated. What are the most common questions that they ask? So obviously the first one is, do I have a claim? But I suppose the other ones, in terms of the most frequently asked questions that we get, do I have to go to court? And as I said there, the answer is usually no. Yes, you do have to go to court if the stars don't align otherwise, and ultimately if your employer won't resolve the case before a hearing date issues, you may have to go to court. But this is it's an entirely voluntary process, and the issue to be aware here as well, and it's a question that I'll touch on later on in relation to costs. There isn't any costs that can be awarded against an individual. So if a claimant decides at the last moment that they don't want to go ahead, they can simply withdraw their claim, and there can't be any consequence for them to do so. Another question we get asked is, will my employer be there? And again, the answer is usually yes, but they don't necessarily, it doesn't necessarily come to that, because a claim could be resolved before that. Now, obviously, as I said at the outset, many of our clients don't take these cases just for the resolution in terms of compensation. So many of our clients actually want their employer there and want their employer to be asked those hard questions. And so, you know, in many cases, our clients actually want the employer to be there. Another question we get asked is, can I get into trouble for doing this? Or is there any, you know, if I'm still employed there, could there be a negative consequence? And the answer is, legally, no, you shouldn't get into trouble for doing it, but practically that doesn't mean that you won't. So I suppose sometimes I say it's a little bit like the speed limits on the roads. There are speed limits there, everybody doesn't obey them. And in the employment circumstance, what we find is that it's a persuasive effect rather than anything else. So there is a provision in the Employment Equality Act called victimization, which means that if you're penalized or victimized as a result of making a complaint, you could have a separate case for that. The Safety, Health and Welfare at Work Act says that if you're penalized for raising a complaint relating to health and safety, which this could be, then again, you could be you could have a cause of action under the Section 27 of the Safety, Health and Welfare at Work Act. The other classic question is, will I have to speak? And again, yes, you might have to speak if you go to a hearing, but that gives you your opportunity to have your say, and so that can be an important thing for people. And the last one, like I said, I suppose I touched on earlier on, who will pay the costs? And that is a significant question, because, like I said, I mean, if you're doing this for the money, you're probably in the wrong place. Like I said earlier, the WRC doesn't make significant awards, and it's probably not the place to go if you're doing it just for the money. I think it should be more than that. And like I said, when we get inquiries, we're not entirely interested in working with the people who are doing it just for the money. we want to make a difference, and we want to help our clients make a difference. So why pursue a claim, or why do our clients pursue a claim? And like I said earlier on, most of our clients aren't doing it for the money. They're doing this because they don't want this to happen to anyone else. And by pursuing a claim, your complaint will be handled externally and independently by an expert, by an adjudicating officer who's trained to deal with it. It's a reasonably straightforward process. And while you won't get your costs if you're successful, it also means that if you're unsuccessful, you don't have to pay the other side's costs. And like I said, most cases settle, but you don't have to. So in terms of what we do as Employment Matters, like I said, we get about 100 inquiries every month. And I suppose we're very well placed. We only take on about 10 new clients a month. We're very well placed, obviously, to give professional expert advice. And often of those inquiries that we get, often we can give somebody a steer in terms of helping them resolve it themselves without having to have recourse to the law. So look, I suppose I'm conscious that it's just 1 o'clock now, and I did say we were going to finish up before 1, so it's 2 minutes past 1. I just see there are a couple of questions there from people, and I just want to maybe touch on a couple of those. I just see a question there from Jane, and Jane's asking, what if I'm on a fixed term contract, and does the law still apply? And it absolutely does. The Employment Equality Act applies to you whether you're employed at all, or whether you've owned, so somebody, for example, who has been who has been unfairly deselected for employment in a recruitment process, so they've never actually been in employment, so it applies to them, or to someone who's only been in the workforce for a week or 2 weeks. And it doesn't matter whether you're on a permanent contract or a fixed term contract, it applies. And interestingly, actually, a place where we come across this at times is where somebody's fixed term contract ends during their pregnancy. And sometimes employers will shrug their shoulders and say, well, look, it is what it is. But that could be determined to be discrimination, in that if the employee would have had their contract extended if they were at work, then the failure to extend their contract just simply because they're on maternity leave could be deemed discrimination. I just see another one there from Mel. My maternity replacement has been kept on doing my job, and I've been offered something different. Is this legal? And again, a lot of these really depend on the circumstances, but the likelihood there is that that's not legal. You should be entitled to return to your own job, to the job that you had prior to your maternity leave. Now, that's not always possible because there may have been a reorganization while you were gone, but you should certainly not return to a job that's any less, that's a lesser job or a demotion. I see one there from Mary who says, how much does this cost? And I suppose, how long is a piece of string? I suppose that's a question that I suppose can only be answered once we understand what's involved. But I suppose the one thing I would say is it does cost money, and people should, I suppose, want is a strong word, but people should expect to invest into their case. There are solicitors out there who will take claims on a no-win, no-fee basis. We don't do that. We can make claims affordable as possible for people, but really, I suppose we want to see clients invest in their cases alongside us, because I suppose litigation is expensive, and like I said, from the perspective of the claimant, we want them to be alongside us with the case that we're taking. I think that's it. I don't see any other questions. So for anybody who has attended, and again, for those who attended previously, My apologies about the rescheduling. And for all of those who've jumped on board today, thanks very much. And if you want to find out any more, please feel free to contact either me or Christina in our office, or any of the staff here. And we wish you well.